Before we dive in, it's crucial to state that this video is for informational and educational purposes only. I am not your lawyer, and this presentation does not constitute legal advice. The entertainment industry is incredibly complex, and you should always consult with a qualified legal professional for advice tailored to your specific situation. Imagine this. You're in a garage in a suburb of Cleveland, Ohio. It's 2 in the morning. You've just written it. The song, the one you know deep in your bones, is going to change everything. You pour every last dime you have into a demo. You send it out, and then the impossible happens. The phone rings. It's a major label in Los Angeles. They love it. They want to fly you out. First class. You walk into an office that's bigger than your entire apartment. Glass walls, platinum records on the wall, a view of the Hollywood Hills. They tell you you're the future. They see the vision, and they slide a contract across a ridiculously expensive mahogany desk. It's 60 pages long. It's dense. It's filled with words you've never seen before, like indemnification, cross-collateralization, and recoupable expenses. But your heart is pounding. This is it. The dream. The A&R guy is smiling, telling you it's standard, just a formality. So you pick up the pen and you sign. And in that single moment, with that one signature, you have potentially just made the single biggest financial mistake of your entire life. You didn't just sign a record deal. You may have just signed away the rights to your own music forever. You may have just agreed to pay back every dollar the label spends on you, from the music video to the catered lunch, before you see a single penny in royalties. You may have even signed away the rights to your own name. This isn't a scare tactic. This isn't fiction. This is the brutal reality for thousands of talented artists who step into the music and film industry, armed with a dream but completely unprepared for the war they're about to fight. The most powerful person in Hollywood isn't the director with the megaphone. It's not the studio head with the 9-figure budget. It's not even the A-list star with 100 million followers. The most powerful person in the entertainment industry is the one you never see on the red carpet. It's the lawyer, the quiet, strategic mind that structures the deals, that writes the contracts, that builds the legal fortresses that protect empires, and just as often, creates the legal traps that bankrupt the unwary. They are the architects of this world. Every movie you watch, every song you stream, every live concert you attend, its very existence is the result of a complex web of hundreds, sometimes thousands of legal agreements. These documents are the invisible scaffolding that holds the entire glittering facade of Hollywood together. And for the creators, the artists, the talent, understanding this world isn't optional. It is the absolute difference between a lifelong career and a cautionary tale. That's why we're here. Over the next 10 parts, we are going to pull back the curtain on the most misunderstood and critically important role in the entire entertainment ecosystem. We are going to demystify the entertainment lawyer. This isn't going to be a dry, boring legal lecture. This is a masterclass in survival. It's a strategic guide to the business of creativity. Whether you're a musician trying to understand your first record deal, a screenwriter trying to protect your script, a YouTuber trying to navigate brand deals, or simply a fan who wants to understand the real power dynamics behind the art you love, this series is for you. We will break down the exact strategies lawyers use to negotiate multi-million-dollar deals. We will expose the hidden clauses in contracts designed to take your rights. We will teach you how to think like a lawyer, so you can protect yourself, your art, and your future. You will learn what a deal memo is and why it can be as binding as a full contract. You'll understand why owning your masters is the holy grail for musicians. You'll discover the difference between net and gross points in a film deal, and why that difference can be worth tens of millions of dollars. This knowledge isn't just power, it's armor. Because the industry is built on a foundation of one single, incredibly valuable concept: intellectual property. IP. It's a term that gets thrown around a lot, but what does it actually mean? Think of it this way. If you build a house, you have a physical asset. You have a deed. You have property lines. You can see it, touch it, and put a fence around it. In the creative world, your song, your script, your film is your house. But it's a house made of ideas. You can't put a fence around an idea. So how do you own it? How do you stop someone from just walking in, taking your melody or your story, and claiming it as their own? That's where the law comes in. The legal system has created invisible fences for your ideas. The two most important ones in this world are copyright and trademark. Copyright is the deed to your creative house. It's the legal right that says you and you alone created this specific expression of an idea, this song, this screenplay, this photograph, and you control what happens to it. You control who gets to copy it, who gets to sell it, who gets to perform it. It is the fundamental building block of all wealth in the entertainment industry. Every dollar generated flows from a copyright. A trademark, on the other hand, is your brand. It's your band name, your logo, the title of your movie franchise. It's the sign on the front of your creative house that tells the world who lives there. It's what distinguishes your product from everyone else's. Protecting that brand is just as crucial as protecting the work itself. An entertainment lawyer is, at their core, a master architect and security guard for your intellectual property. Their first job is to help you secure your rights, to make sure you've properly registered your copyrights, to ensure your band name is trademarked so another group can't just start using it. They establish the legal foundation, the deed to your property, so that no one can question that you own what you created. But that's just the beginning. Once you own the house, the real game starts. The lawyer's job then shifts to monetizing it. They are the real estate agents, the developers, the deal makers. A record label doesn't want to buy your song. They want to license your copyright. A movie studio doesn't want to buy your script. They want to option the right to turn your copyrighted screenplay into a film. Every single one of these transactions is a negotiation. It's a high-stakes chess match where every single word in a contract matters. And the person on the other side of the table? They have an entire team of brilliant, experienced lawyers whose only job is to get the best possible deal for the studio or the label. Not for you. They write the contracts. They know every loophole, every trick, every clause that looks harmless but can strip you of your rights and your money down the line. Going into that negotiation without your own expert, your own lawyer who lives and breathes this world, is like walking onto a battlefield with a butter knife. You might be the most talented artist in the world, but in that room, talent is irrelevant. The only thing that matters is the leverage you have and the terms written on that piece of paper. The lawyer's job is to be your general, to analyze the enemy's position, to craft your strategy, and to fight for every single inch of ground. They know what's standard, what's negotiable, and what's a flat-out predatory trap. They are the translators, turning that dense 60-page legalese into a simple question. Is this deal good for you or is it not? They are your shield, protecting you from the pitfalls of the industry, but they are also your sword, fighting to get you the compensation and the creative control you deserve. From clearing the rights to a sample in a hip-hop track to ensuring a film has the proper insurance to cover a dangerous stunt, their work touches every facet of the creative process. They are the risk managers, the strategists, and the guardians of the art. Without them, the entire industry would grind to a halt in a flood of lawsuits and chaos. So, as we embark on this journey, the first thing to understand is this. The entertainment industry is not one industry. It's two. There's the industry of art, the creation, the passion, the performance. And then there's the industry of business, the contracts, the rights, the money. You cannot succeed in one without mastering the other. The lawyer is the bridge between those two worlds. They are the ones who turn art into an asset, and a passion into a profession. But before a lawyer can negotiate a multi-million-dollar movie deal, or structure a record-breaking album rollout, they have to start with the single most valuable, most fundamental asset in this entire universe. An asset so powerful it can be bought, sold, and stolen, often without the creator even realizing it. And it all begins not with a signature but with a single simple idea. That idea, that spark of a melody in your head, that line of dialogue you jot down on a napkin, that's where it all begins. In the United States, the moment you fix that creative expression in a tangible form, meaning you write it down, record it on your phone, type it into a document, something incredible happens. It's a moment of legal alchemy. Without filing a single piece of paperwork, without paying a single dollar, you have just created a powerful legal property. You've created a copyright. This is one of the most misunderstood concepts in the entire creative world. Most people think you have to mail something to yourself or register with the government to get a copyright. And while formal registration with the U.S. Copyright Office is critically important for enforcement, we'll get to why that's the key to the courthouse door later. The right itself is born automatically. It springs into existence fully formed, like a goddess from the sea, the second your pen leaves the paper or you hit stop on the voice memo. And this is precisely where the first lawyer, the first guardian, should enter the picture. Because that newborn asset, your copyright, is beautiful, full of potential, and incredibly vulnerable. It's like a baby animal in a jungle filled with predators. And the predators in this jungle don't have claws and teeth. They have contracts and clauses written in dense, impenetrable legalese. Let's imagine a songwriter. Her name is Maya. She's in her small apartment in Silver Lake, Los Angeles, with a cheap acoustic guitar. After weeks of struggle, a melody and a lyric finally click into place. It's a song that feels special, a song that has a piece of her soul in it. She records a rough version on her laptop. Boom! Copyright exists. She now, in the eyes of the law, has a bundle of exclusive rights to that song. What are these rights? Think of it not as one single thing, but as a bundle of sticks. Each stick represents a different way you can make money from your creation. There's the right to reproduce the song, to make copies like pressing it onto vinyl or creating MP3 files. There's the right to distribute it, to sell those copies in stores or on iTunes. There's the right to perform it publicly, to play it at a concert or have it broadcast on the radio. And then there's the big one, the one that builds empires, the right to create derivative works. This means the right to take your original creation and transform it into something new. A remix of your song? That's a derivative work. A movie that uses your song in a key scene, what's called a synchronization license. A derivative work. A translation of your lyrics for a foreign market? You guessed it. Each one of those sticks in the bundle is a separate sellable licensable asset. Maya, high on the thrill of creation, plays her new song at an open mic night. A local, small-time music producer is in the audience. He's blown away. He comes up to her afterwards, full of compliments. "That song is a hit," he says. "I have a small studio. Let's record it properly. I'll do it for cheap, just a few $100 to cover my time. Just sign this simple one-page agreement." Maya's ecstatic. This is her first break. She looks at the paper. Seems straightforward. It says he'll produce the track, and in exchange, he gets a small percentage, and it mentions something about a work for hire. Seems fair. She doesn't have a lawyer. Why would she? It's just a demo. She signs it. In that single, uninformed moment, she may have just given away the entire kingdom. That term, work for hire, is one of the most dangerous phrases in creative contracts. In the context of copyright, it can mean that the person who paid for the work, in this case the producer, is legally considered the author and owner of the creation from its inception. Not Maya. By signing that paper, she might have just legally transferred the parentage of her creative child to a stranger. That producer might now own the master recording, and potentially, depending on the wording, a share of the underlying song itself. He could now be the one who controls that entire bundle of sticks. He could sell it to a Hollywood movie, and Maya wouldn't see a dime. This is not a scare tactic. This happens every single day. The role of an entertainment lawyer, at this fundamental embryonic stage, is to act as a translator and a shield. Their job is to read that simple one-page agreement and see the landmines. They would immediately cross out work for hire and replace it with language that establishes a non-exclusive license for a limited purpose. They would ensure that Maya retains 100% ownership of her song, the composition, the lyrics, the melody, and that the producer is being paid for a service, perhaps with a small, clearly defined percentage of the revenue from that specific recording, not from the song itself. The lawyer isn't just protecting Maya from the producer. They are setting up the entire foundation for her future career. They are building the fortress walls around her intellectual property before the first attack even comes. Now let's shift from music to film. It's the exact same principle, just on a different scale. A screenwriter, let's call him Ben, spends a year of his life pouring everything he has into a script. He types fade out. On page 110, in that instant a copyright is born. That script, that collection of characters and plot and dialogue, is his property. It is an asset just like a house or a block of stock. An independent producer reads the script and loves it. He wants to option it. An option agreement is essentially a rental agreement for intellectual property. The producer pays the writer a small amount of money for the exclusive right to try and get the movie made for a specific period, say 18 months. If he succeeds in getting the funding and a studio attached, the option allows him to then buy the script for a pre-negotiated purchase price. Sounds simple, right? But the devil is in the details, and those details can create entire universes of financial and creative heartbreak. What are the terms of the option extension? What is the purchase price, and does it escalate based on the film's budget? Does the writer get a bonus if the film is a box office hit? What about sequel rights? Prequel rights? TV series spin-offs? Does Ben, the writer, retain the right to write the novelization or the Broadway play? Without a lawyer, Ben is just a writer who is thrilled someone wants to make his movie. He sees a check and a chance at his dream. With a lawyer, Ben is a business owner negotiating the sale and potential franchising of his primary asset. The lawyer's job is to think 10 steps ahead, to imagine a world where this isn't just one movie, but a massive multi-billion-dollar franchise like Star Wars or Harry Potter, all of which began as words on a page, as a copyright. The lawyer is there to ensure that if that lightning strikes, the person who created the storm gets to participate in the upside. They fight for every stick in that bundle. They ensure that for every new derivative work, every sequel, every video game, every action figure, a new negotiation is triggered, and a new stream of revenue flows back to the original creator. They are the architects of a creator's legacy. So, the first and most fundamental role of a lawyer in the entertainment industry is not to stand up in a courtroom. It's to sit down in a quiet office with a creator, a contract, and a red pen. It's to be a guardian at the gate of a brand new idea. They are there to protect that initial spark, that fragile piece of intellectual property, from a world that is designed to take it for the lowest possible price. They are there because a signature is a weapon, and they are the only ones who can ensure it's pointed in the right direction. For Maya and Ben, their initial creations have now attracted attention. But this is just the beginning. The small-time producer and the independent option are the little leagues. What happens next is the call-up to the majors. The giant record labels, the powerful publishing companies, and the monolithic movie studios are about to enter the scene. And the one-page agreements are about to be replaced by 50-page contracts so dense they could be used as a boat anchor. The stakes are about to go from protecting an idea to building an empire, or losing one before it's even built. This is where the game changes, because for every wide-eyed artist with a dream, there was now a corporation with a balance sheet. And the language of dreams, passion, art, expression, is not the language of balance sheets. The language of balance sheets is leverage, liability, and long-term asset acquisition. And who speaks that language? Not the kid with the guitar. Not the starlet with the perfect smile. The lawyer does. Imagine Hollywood in its golden age, or the Music Row of the 1960s. It wasn't just about talent anymore. It was an assembly line. The studios and the record labels had perfected a machine designed to do one thing: extract maximum value from creative talent for minimum cost. The fuel for this machine was the contract. Not a one-page agreement, but a thick, intimidating stack of paper known as the Standard Form Agreement, or the boilerplate. The boilerplate contract is one of the most brilliant and brutal inventions in corporate history. It's presented as standard. The executive slides it across the polished desk and says, "Everyone signs this. It's just how we do things." But this document wasn't written by a neutral party. It was crafted over years by the sharpest legal minds the company could afford, with every single clause, every subsection, every comma and period, designed to benefit one party and one party only, the company. For an artist, signing one of these without a lawyer was like walking into a labyrinth blindfolded. You might feel like you're moving forward, but every path has been predetermined to lead you right back to the center, where the house always wins. This is where the entertainment lawyer first earns their keep, not as a warrior, but as a translator, as a guide. Their first job is to turn on the lights in that labyrinth. They sit down with the artist and they start decoding the hieroglyphics. Let's take a classic record deal from that era. The label offers a young band a $100,000 advance. To the band, living on ramen and sleeping in a van, this is like winning the lottery. They see $100,000. The lawyer sees a trap. First, the lawyer explains that the advance isn't a gift. It's a loan. A loan that must be paid back before the band sees a single penny in royalties. And it's not just a loan. It's a recoupable expense. The lawyer then points to a dense paragraph buried on page 27. This paragraph says that it's not just the $100,000 advance that's recoupable. The recording costs, recoupable. The producer's fee, recoupable. The money the label spends on music videos, radio promotion, and tour support, all of it is added to the artist's debt. Suddenly, that $100,000 windfall is actually a $500,000 hole the band has to dig themselves out of. But it gets worse. The lawyer flips to the section on royalties. The contract proudly states the band will receive a 15% royalty on all sales. Sounds fair, right? But the lawyer knows the devil isn't just in the details. He is the details. They point out the deductions. There's a 25% packaging deduction, supposedly for the cost of the CD jewel case or the vinyl sleeve, even though it costs a fraction of that. There's a 10% deduction for free goods. which means the label assumes 10% of all records are given away for promotion and pays no royalties on them, whether they're actually given away or not. There's a deduction for breakage. There are deductions for foreign territories, for compilation albums, for television sales. By the time the lawyer finishes explaining all the deductions from the 15% royalty, the artist's actual take-home percentage is closer to 4%. And that's 4% of a reduced wholesale price, not the retail price you see in the store. So an album that sells 1 million copies, a certified platinum hit, might not generate enough money to pay back the initial debt. The band could have the #1 album in the country and still be, on paper, broken in debt to the very company selling their music. And then comes the kill shot. The lawyer points to the clause on ownership of the masters. The master recordings, the original source from which all copies are made, are the single most valuable asset. The lawyer explains that according to this standard contract, the label doesn't just have the right to sell the recordings, they own them, forever, in perpetuity throughout the universe. The band, the people who wrote the songs and bled in the studio, are essentially employees who have created a permanent asset for a corporation. They will never own their own work. They have sold their soul without even realizing it. This is the first critical role of the lawyer, to prevent the catastrophic mistake. To be the one person in the room whose only job is to protect the artist's interests. To translate the legalese into plain English and say, "Do you understand that this deal means you could sell 1 million records and owe us money? Do you understand that you are giving away the rights to your life's work forever?" Now let's pivot to Hollywood. The same dynamic was at play, but on an even grander scale. The old studio system was built on the 7-year contract. An actor would be signed, often as a teenager, and the studio would control every aspect of their life. Who they dated, what they wore, which films they appeared in. It was a form of indentured servitude with better lighting. Lawyers were instrumental in breaking this system. The famous case of Olivia de Havilland in the 1940s set a precedent that a studio couldn't just suspend an actor and add that suspension time to the end of their 7-year contract, effectively trapping them indefinitely. It was a legal battle that reshaped the power dynamic in Hollywood forever. But even after the old studio system crumbled, new traps emerged. The most famous of these is the myth of net points. When a big movie is being put together, an actor or director might be offered a smaller upfront fee in exchange for a percentage of the film's profits, known as points. It sounds like a great deal. If the movie is a blockbuster, you become a millionaire overnight. But the lawyer's job is to ask the crucial question. A percentage of what? The studio will almost always offer net points. A percentage of the profits after all expenses have been deducted. And here's the dirty little secret of Hollywood accounting. There are almost never any net profits. A savvy lawyer knows this. They've seen the studio's expense reports. They know that a studio can load up a film's budget with so many fees, distribution fees, marketing overhead, administrative costs, interest charges, that even a movie that grosses $1 billion worldwide can, on paper, show a net loss. The famous novel and film Forrest Gump reportedly never showed a net profit, despite being one of the most successful movies of all time. The author who sold the rights for net points got nothing. The actor who negotiated for gross points made a fortune. And that is the second, more advanced role of the lawyer. Not just to be a shield, but to be a sword. They don't just say no to a bad deal, they architect a good one. An experienced film lawyer will laugh at an offer of net points. They will cross it out with a thick red pen and write in gross points. They will fight for first dollar gross, meaning the client gets a percentage of every single dollar that comes into the box office, before any of the studio's creative accounting can make it disappear. They will negotiate for approvals over the script, the director, the co-stars. They will define the size of the actor's trailer, the number of first-class plane tickets they receive, the credit they get on the movie poster. They build a fortress of contractual protections around their client. In music, they fight to put a cap on recoupable expenses. They argue for a higher royalty rate. Most importantly, they fight for ownership. They might not be able to get the artist to own their masters on the first deal, but they will insert a reversion clause. A clause that says after a certain number of years, say 35 years, the ownership of the master recordings reverts back to the artist who created them. This is the transformation. The lawyer evolves from a simple contract reviewer into a strategic architect of a career. They are no longer just a cost of doing business. They are an investment in survival and prosperity. They are the ones who understand that a single sentence in a contract signed today can determine whether an artist is a wealthy icon in 30 years, or a cautionary tale playing in dive bars, wondering where all the money went. The battle is no longer just for a fair wage. It's a battle for a legacy. So let's pull back the curtain on one of the most controversial and powerful contractual mechanisms ever devised by the modern music industry: the 360 deal. The name itself sounds holistic, like a warm embrace of an artist's entire career. But for the unprepared, it can feel less like an embrace and more like a boa constrictor. To understand the 360 deal, you have to understand the panic that created it. When the digital revolution shattered the old model of selling physical albums, record labels saw their primary revenue stream evaporate. They were terrified. They were looking at artists who were selling fewer and fewer records, but were making millions on the road, selling out arenas, moving mountains of merchandise, and signing lucrative endorsement deals. And the labels, who had often spent millions to break that artist, weren't seeing a dime of it. Their solution was the 360 deal, or the multiple rights deal. The premise was simple, and from a business perspective brutally logical. The label would argue, "We are not just a record company anymore. We are your business partner. We are investing in your brand. Therefore, we are entitled to a percentage of all revenue streams that flow from that brand." Suddenly, the contract wasn't just about album sales and publishing. It was about everything: touring revenue, merchandise sales, endorsement deals with sneaker companies, fan club fees, even, in some of the most aggressive contracts, revenue from acting gigs or book deals. The label wanted a piece of the full 360 degrees of an artist's career. Imagine you're a young, talented musician. You've been playing in cramped clubs for years, sleeping in a van, pouring your soul into your music. Then one day a major label offers you a deal. They're offering a 7-figure advance. The number is staggering. It's more money than your family has ever seen. It's the validation you've dreamed of. They slide a thick contract across the polished mahogany table. They tell you it's standard. They call you partner. This is where the dream can curdle into a nightmare. Without a lawyer, that word, partner, is just marketing. With a lawyer, it becomes a negotiation. The artist sees the advance. The lawyer sees the recoupment. That massive check isn't a gift. It's a loan. And under a 360 deal, the label can recoup that loan not just from your record sales, but from the money you make selling t-shirts at a concert. The artist sees the promise of marketing support. The lawyer looks for the commitment. Many contracts are written passively, stating the label may promote the album. A good lawyer fights to change may to shall. They fight for a guaranteed marketing budget, a commitment to produce a certain number of music videos, a tour support clause that isn't just another loan in disguise. But the real battlefield is the percentages. The label might ask for 20 to 30% of your net touring income. Your lawyer steps in and asks, "What is the definition of net? Are we deducting the salary for the road crew? The cost of renting the bus? The lighting rig? The insurance?" The lawyer fights to define every single expense, ensuring the label's cut comes from actual profit, not gross revenue that's already been spent just to put on the show. The label wants 25% of merchandise. The lawyer argues that they have nothing to do with designing or manufacturing your merchandise, so their share should be far less, maybe 10%, and it should only apply to merchandise that uses the album art they funded, not your personal brand logo. This is a high-stakes game of chess, where every word matters. The lawyer isn't just a proofreader. They're a strategist, a fortune teller, a defender of a future that the artist is too blinded by the present to see. They might negotiate for a sunset clause, ensuring that the label's rights to non-record revenue expire a few years after the contract term ends. Without this, an artist could be paying a piece of their concert ticket sales to their old label a decade after they've left. They fight to carve out exceptions. An artist who is also a novelist, the lawyer will fight to exclude book publishing from the deal. A singer who has aspirations to act, the lawyer will draw a red line around any income derived from film and television. Each of these points is a battle. The label's attorneys are brilliant, and their goal is to maximize the company's return on investment. They will push back, claiming their investment in the music is what makes all these other opportunities possible. And they're not entirely wrong. This is the gray area where careers are made or mortgaged. The lawyer's job is to navigate that gray, to find the compromise that allows the artist to get the support they need without signing away their financial future. They might trade a slightly higher percentage on merchandise for a complete carve-out of touring revenue. They might agree to a small percentage of endorsements, but only for deals that the label actively helps to secure. This isn't just about money, it's about control. It's about creative freedom. The 360 deal can create a dynamic where the label has a vested interest in pushing an artist to tour relentlessly, even to the point of burnout, because that's where the immediate recoupable money is. It can lead to pressure to take on endorsement deals that don't align with the artist's brand. The lawyer's role is to build firewalls into the contract to protect the artist's autonomy and long-term health, both creatively and personally. This same ferocious battle over rights and revenue is mirrored in the film industry, but the pieces on the board are different. Instead of masters and publishing, the fight is over intellectual property, profit participation, and creative control. When an actor signs on to a blockbuster superhero movie, the contract they sign is a labyrinth of clauses that will define their life for the next decade. The lawyer isn't just negotiating the salary for this one film. They're negotiating the number of sequels they're obligated to appear in. They're fighting over the billing, whether their name appears before or after the title, a seemingly vain detail that has massive implications for an actor's status and future earning power. They are deep in the weeds of profit participation, one of the most famously complex and often illusory concepts in Hollywood. An actor might be promised points on the back end, a percentage of the film's profits. Sounds great, but a sharp entertainment lawyer knows all about Hollywood accounting, the dark art of making a billion-dollar blockbuster appear to have made no profit at all. They do this by loading the film's expenses with massive distribution fees, overhead charges, and marketing costs, often paid to subsidiary companies owned by the same parent studio. The lawyer's job is to fiercely negotiate the very definition of profit. They will fight for points on the gross revenue, not the net. They will demand audit rights, the ability to send in their own accountants to examine the studio's books and challenge the fuzzy math. This is the difference between a life-changing payday and a worthless piece of paper. For a screenwriter who sells a script, the lawyer's fight is about legacy. The studio wants to buy the script outright, a work-for-hire agreement that gives them total ownership forever. The lawyer fights for the writer to retain certain rights, perhaps sequel rights, television series rights, or at the very least a reversion right, which means if the studio doesn't produce the film within a certain number of years, the rights revert back to the writer. This single clause can be the difference between a writer's brilliant story sitting on a shelf collecting dust for eternity, and them getting a second chance to get it made elsewhere. From the recording studio to the film set, the entertainment lawyer is the guardian of the what-ifs. What if the song becomes a global anthem? What if the movie spawns a franchise? What if your face ends up on a lunchbox, a video game, a theme park ride? The executives and agents are focused on the deal in front of them. The lawyer is focused on the architecture of a career. They are building a fortress of contractual language designed to protect the artist not just from the other side of the table, but sometimes from their own short-sighted ambition and a desperate desire to say yes. Because in Hollywood, the contract isn't just about the movie you're making today. It's about every character you will ever become. And this trap, this contractual cage, isn't always built by a mustache-twirling executive. Sometimes the artist builds it themselves, brick by desperate brick. Imagine you're an actor. You've been waiting tables for 10 years, going to 1,000 auditions, getting rejected 999 times. Then you land it. The role. It's the quirky, lovable sidekick in a blockbuster superhero movie. The contract slides across the table. It's thick. It's intimidating. But it has a lot of zeros on it. Your agent is thrilled. Your family is ecstatic. All you can see is the finish line. You sign. The movie is a smash hit. You're a star. But then you read the fine print your lawyer tried to warn you about. The studio has an option on you for 6 more movies. Not only that, but they have a character rights clause. You can't play any other role that is substantially similar to your breakout character. Suddenly, every audition you get is for another quirky, lovable sidekick. The dramatic roles you dreamed of? The indie films? The studios won't touch you. They see you as one thing and one thing only. The contract you signed didn't just get you a job. It cast you in a role for the next decade of your life. You're not an actor anymore, you're a product. And the manufacturer has exclusive rights. This is the nightmare scenario. And it's a mirror image of the most feared, most controversial, and most common contract in the modern music industry. The 360 deal. To understand the 360 deal, you have to understand how the music business collapsed and then rebuilt itself. For decades, the model was simple. A record label signed an artist. They paid for the recording, the manufacturing, the distribution, and the promotion of an album. In return, they took the lion's share of the profit from album sales. The artists made their real money from touring, from selling t-shirts, from fan clubs. The label didn't touch that. A tour was just considered a very expensive form of promotion for the album, which was the real prize. Then came the internet. Napster, LimeWire, iTunes, Spotify. Suddenly the album, this physical, profitable product, evaporated. People weren't buying music anymore. They were streaming it or stealing it. The label's primary revenue stream dried up to a trickle. A billion-dollar industry was on its knees. So they adapted. They looked at their artists and saw the whole picture. They saw the thousands of fans screaming at a concert. They saw the endless lines at the merchandise booth. They saw the brand sponsorships, the TV appearances, the movie roles. And they said, why are we only getting a piece of the least profitable part of this artist's career? We're investing millions to build them from nothing. We should get a piece of everything. And so the 360 deal was born. The 360 refers to the full circle of an artist's career. In this model, the record label doesn't just get a percentage of your record sales. They get a percentage of your touring revenue, your merchandise sales, your publishing royalties from songwriting, your endorsement deals with sneaker companies, your paid appearance at a nightclub in Vegas. Even in some of the most aggressive contracts, your acting salary if you get cast in a movie. They get a piece of every single dollar that comes into your life that is in any way connected to your career as an artist. For a young, hungry artist, this deal can sound like a dream. The label comes in with a huge advance check. They promise a massive marketing budget, a world-class producer, a music video directed by a legend. They're not just a record company. They're your full-service career partner. They'll help you build your brand, your empire. And all they ask for is a small piece of the pie. Typically, somewhere between 10 and 25% of all your non-record income. Here's where the lawyer earns their entire fee for the next 10 years. Because that artist, blinded by the advance check and the promise of fame, doesn't see the reality. Let's do the math. You sign a 360 deal. The label gives you a $300,000 advance. First, remember that advance is just a loan. You have to pay it all back before you see another penny from record sales. That money goes to recording the album, making videos, paying your producer. It's gone before you even know it. Now the album comes out. It's a modest hit. You go on tour. You work your tail off for a year, playing 200 shows in 200 different cities. You're exhausted, but you're packing 2,000-seat venues every night. The tour grosses $3 million. Amazing, right? But after paying for the bus, the crew, the lights, the sound, the venue fees, the manager's commission, the agent's commission, your net profit is maybe $400,000. But wait, your 360 deal says the label gets 20% of your net touring revenue. So they take $80,000. You also sold $500,000 in t-shirts and hoodies. After paying for the manufacturing and the staff to sell it, you made $150,000. The label takes another 20% of that. That's $30,000. Meanwhile, your album streams are trickling in, but all that money is going straight to the label to pay back that $300,000 advance. You're a star. You're on the radio. People stop you on the street. And after a year of brutal non-stop work, you might personally take home less than your road manager. You are the face of a multi-million-dollar enterprise and you are broke. This is the trap. And a good music lawyer is the only person who can help you navigate it. Their job isn't necessarily to kill the 360 deal. In today's industry, that's often impossible. The labels have all the leverage. Their job is to make it survivable. They fight tooth and nail over every single percentage point. They argue that 20% is too high, it should be 15. They fight to exclude certain things. For example, if you were already a successful songwriter for other artists before you signed, your lawyer will fight to carve out that publishing income, arguing the label had nothing to do with creating that revenue stream. They will fight viciously over definitions. What constitutes merchandise? Does it include a book you write? Podcast you start? The label will try to make the definition as broad as humanly possible. The lawyer's job is to make it as narrow as a razor's edge. But the single most important clause they will fight for is called a sunset clause. This is everything. A sunset clause dictates what happens after your contract with the label is over. Without one, the label could argue that since they helped build your career, they are entitled to a piece of your touring and merchandise income. Forever. For the rest of your life. A sunset clause puts a time limit on their participation. A great lawyer will negotiate a deal where, after the contract term ends, the label's percentage decreases each year for a few years, and then goes to zero. The sun literally sets on their right to your money. Without that clause, the deal you signed when you were 19 and desperate could financially cripple you when you're 50 and a global icon. It's the difference between being a business partner and an indentured servant. The lawyer understands that the deal isn't about the first album. It's about the fifth. It's about the reunion tour 20 years from now. It's about ensuring that the empire you build is actually yours, and not just a property you're renting from the company that gave you your first break. The contract is a story, and a lawyer is trying to write you a happy ending, while the other side is perfectly content to write you into a tragedy, as long as it makes them a profit. They control the money, the marketing, the machine. But what happens when the contract gives them control over the one thing that is truly yours, the art itself? This is the ultimate nightmare for any creator. The idea that the song you bled for, the script you spent sleepless years perfecting, could be taken, twisted, and owned by someone else. It's not just business, it's a violation. And it happens every single day in Hollywood and Nashville. The weapon they use is the very contract your lawyer is supposed to protect you from. Specifically, they target your intellectual property or IP. Now, intellectual property sounds like a boring corporate buzzword, but it's the legal term for the most valuable thing in entertainment. The idea itself. It's the melody in your head, the characters in your story, the world you built from nothing. Copyright is the legal shield that protects it. It's the deed to your creative house. When you sign a contract, you're not just agreeing to a salary, you're negotiating the terms of who gets to live in that house, who gets to renovate it, and most importantly, who holds the deed. In music, this gets incredibly complicated. There are two main copyrights for every single song you hear. First, there's the composition, which is the melody and lyrics, the song itself as it would be written on sheet music. This is controlled by what's called publishing rights. Second, there's the master recording, which is the specific audio recording of that song, the actual file you stream on Spotify. Think of it this way. The composition is the blueprint for a house. The master recording is the one specific house that was built from that blueprint. Anyone can use the blueprint to build their own version of the house. That's a cover song. But only one person owns the original house that was built first. The record label's primary goal is to own that original house. They want the master. For decades, the standard industry contract was simple. The label pays for the recording, the marketing, the distribution, and in exchange, they own the master recordings. Forever. It sounded like a fair trade to a young artist desperate for a shot. But what happens when that artist becomes the biggest star on the planet? Let's talk about Taylor Swift. In 2005, as a teenager, she signed a deal with a new label, Big Machine Records. That deal gave them ownership of the masters for her first 6 albums. 6 albums. That's everything from Tim McGraw to the cultural behemoth that was 1989. She wrote the songs, she performed the songs, she lived the songs. But the label owned the recordings. When her contract was up, she tried to buy her masters back. The label, according to her, presented a deal where she could earn back one old album for every new album she delivered. It was a golden handcuff scenario. She would have to mortgage her future to reclaim her past. She walked away. Then, Big Machine Records was sold to a company run by Scooter Braun for a reported $300 million. A huge portion of that valuation was Taylor Swift's master recordings. Her life's work had been sold to someone she considered a bully, without her even having a chance to bid on it herself. Imagine that. The diaries of your youth, the sonic photographs of your life, sold to the highest bidder. This is where the story turns from a cautionary tale into a masterclass in legal strategy. Her old contract, the one that gave away her masters, likely had a re-recording restriction. This is a standard clause. It says the artist cannot re-record their own songs for a specific period of time after the contract ends. Maybe 2 years, maybe 5. The label's lawyers put that in to protect their investment. They don't want a competing version of their asset on the market. But Taylor's lawyers knew something crucial. That clause had an expiration date. And Taylor, as the songwriter, still controlled the other half of the equation. The publishing rights. The blueprint. So when the restriction period ended, she announced she was going back into the studio to re-record her first 6 albums, note for note. She would create new master recordings, new houses from the original blueprints. And these new masters? She would own them completely. The result was Taylor's version. It was a brilliant legal checkmate. She couldn't extinguish the old recordings, but she could devalue them. By encouraging her massive fanbase to only stream and buy Taylor's version, she effectively turned the originals, the ones owned by Scooter Braun, into museum pieces. She seized control of her own legacy. It was a move that sent shockwaves through the industry, a power play made possible by a deep understanding of copyright law and contract loopholes. Her lawyers didn't just win a case, they orchestrated a revolution. This fight over ownership is even older and, in some ways, more tragic in the film and comic book world. Let's go back to 1938. Two kids from Cleveland, Jerry Siegel and Joe Shuster, have an idea for a character, an alien from a doomed planet, raised in America's heartland, a champion of the oppressed. They called him Superman. They sold the complete rights to Superman to Detective Comics, which would later become DC Comics, for $130. 130, and a 10-year contract to write the stories. That $130 check is arguably the most expensive check ever cashed in entertainment history. Superman became a global icon, generating billions upon billions of dollars through comics, radio shows, television, and blockbuster movies. Siegel and Shuster saw almost none of it. They were eventually fired from the very company they helped build. For decades, they fought legal battles to be recognized, let alone compensated. They lived in relative obscurity, at times facing poverty, while their creation was arguably the most famous fictional character on Earth. Their story is the ultimate cautionary tale of what happens without a savvy lawyer in your corner, at the very beginning. The contract they signed was an ironclad transfer of all rights. The concept of creators' rights didn't really exist in the corporate mindset then. It took until the late 1970s, as the first big-budget Superman movie was being made, for their plight to gain public attention. Other comic creators, now successful themselves, rallied to their cause, facing a public relations nightmare, and likely some legal pressure behind the scenes. Warner Communications, the parent company of DC, finally gave in. Their lawyers negotiated a settlement. Siegel and Shuster were given a yearly pension for the rest of their lives, and perhaps most importantly, the credit. Superman, created by Jerry Siegel and Joe Shuster, which would be required to appear on all future comics, films, and shows. They never got ownership back. They never saw a fraction of the billions their creation earned. But their lawyers clawed back a piece of their dignity and secured their legacy. It was a legal battle that spanned 40 years, a fight to correct a foundational sin of the entertainment industry. In both of these stories, the lawyer's role evolved. In the beginning, a lawyer is a shield, meant to protect you from signing a deal like Siegel and Shuster's. They are meant to be a fortune teller, looking into the future and asking the what-if questions. What if this album goes diamond? What if this script becomes a franchise? What if the company gets sold? They fight for clauses like reversion rights, which state that after a certain number of years, the rights revert back to the creator. They argue for better royalty rates, for creative controls, for a seat at the table. They build a fortress of contractual protections around your art. But sometimes, even the best-built fortress isn't enough. When the initial deal is flawed, or when the other side simply has more power, the lawyer's role shifts from architect to warrior. They become the ones leading the charge to reclaim what was lost, like Taylor Swift's team did, or to fight for justice like the lawyers who finally got Siegel and Shuster their credit. They use the law not just as a shield but as a sword. They have to navigate a system that was, for a very long time, designed to transfer ownership from the artist to the corporation. And that system doesn't give up its assets without a fight. The contracts are dense, the litigation is expensive, and the studios and labels have armies of attorneys on retainer. So what happens when your one lawyer, your champion, has to go to war against a corporate giant? What does that battle actually look like? It starts not with a bang but with a letter. A single, deceptively simple envelope, delivered by courier, containing a document drafted on the finest letterhead. It's called a demand letter, or a cease and desist, and it is the first shot fired in a war you never wanted to fight. The language is cold, precise, and utterly ruthless. It will list your alleged transgressions, cite obscure clauses from a contract you signed years ago, and demand immediate compliance, often accompanied by a threat of seeking damages in the 7- or 8-figure range. Your heart plummets. This letter is designed to do one thing: terrify you into submission. This is the moment your lawyer earns their entire fee. They read that same letter not with fear, but with a surgeon's eye, looking for weaknesses, overstatements, and points of leverage. They see the posturing for what it is. The battle begins here, in what's called the pre-litigation phase. This is a brutal, high-stakes poker game played entirely through emails and phone calls between the lawyers. The studio's legal team, often a massive, prestigious firm, will try to overwhelm your single attorney. They'll send over a mountain of documents, citing precedent from a dozen different cases, all in an effort to show that their position is unassailable and that you are facing a legal tidal wave. Their goal is to make a lawsuit seem so expensive, so time-consuming, and so emotionally draining that you'll take whatever lowball settlement they offer just to make it go away. Your lawyer's job is to hold the line. They have to project unwavering confidence, even if they're up against 10 opposing attorneys. They meticulously craft a response, dismantling the studio's arguments point by point. They don't just argue the law, they argue the optics. They might hint at the potential for bad press, reminding the studio that a public fight with a beloved artist is a PR nightmare. They start their own process of discovery, demanding emails, internal memos, and financial records from the studio. This is where the giant size can become a weakness. A massive corporation has millions of documents, and somewhere in that digital haystack might be the needle, the one email, the one memo that proves your case. Finding it is the challenge. Think of the legendary battle between George Michael and Sony Music in the early 90s. He was one of the biggest stars on the planet, but he felt his contract amounted to professional slavery. He sued his own label to be released from his contract, a move that was virtually unheard of at the time. Sony's legal team painted him as a spoiled, ungrateful pop star who didn't want to honor his commitments. His lawyer had to reframe the entire narrative. This wasn't about a pop star having a tantrum. It was a fundamental fight for an artist's creative freedom against a monolithic corporation that saw him as a product, not a person. The legal battle was ferocious and astronomically expensive. George Michael didn't work for years, pouring his fortune into the fight. In the end, the court sided with Sony, but the public pressure and the sheer cost of the fight led to rival labels buying out his contract. He lost the legal case, but in many ways he won the war for his own autonomy. That battle required a lawyer who was not just a legal scholar, but a master strategist and a public relations savant. If this high-stakes negotiation fails, you enter the formal litigation process. And this is where the psychological warfare truly begins. The first stop is often the deposition. You, the artist, will be forced to sit in a sterile conference room for 8, 10, maybe 12 hours, while a team of the studio's lawyers interrogates you under oath. Every word is recorded by a court reporter. They will ask you the same question a dozen different ways, trying to trip you up. They'll dig into your personal life, your finances, your past failures. They'll take your words out of context and twist your intentions. It is a grueling, soul-crushing experience designed to break you. Your lawyer sits beside you, a silent guardian. They can't answer for you, but they object to improper questions. They call for breaks when they see you're fading, and they provide the moral support to get you through the ordeal. Their presence is the only thing standing between you and the corporate machine designed to grind you down. Then come the motions. Before you ever see a jury, the studio's army of lawyers will file a motion to dismiss, or a motion for summary judgment. In plain English, these are legal maneuvers designed to get the judge to throw your case out of court before it even starts. They'll argue that, even if everything you claim is true, you have no legal basis to sue. This is often the most critical phase of the fight. It's a battle of pure legal scholarship, fought through hundreds of pages of written briefs. Your lawyer has to out-research, outright, and out-argue a team with virtually unlimited resources. If they win this motion, you get your day in court. If they lose, it's all over. A more recent and perhaps more illuminating example is Scarlett Johansson's lawsuit against Disney over the release of Black Widow. Her contract, drafted in a pre-pandemic world, guaranteed an exclusive theatrical release, with her biggest bonuses tied directly to box office performance. When Disney decided to release the film simultaneously on its streaming service, Disney+, it fundamentally changed the deal. Disney's lawyers argued that the contract didn't explicitly forbid a streaming release. Johansson's lawyer, however, had to argue the intent of the contract. He had to tell a story. The story of a deal made in good faith, where everyone understood that box office success was the goal. He had to prove that Disney knowingly sacrificed box office revenue to boost its own streaming platform, and in doing so, deprived his client of tens of millions of dollars. This wasn't just a contract dispute. It was a landmark case for the entire industry in the streaming age. Disney's legal team went on the offensive, publicly releasing her salary details to try and paint her as greedy. It was a classic tactic: shame the artist into silence. But her lawyer didn't back down. He fired back in the press, accusing Disney of a misogynistic attack and of hiding behind the pandemic to breach a contract. He turned Disney's PR move into a PR disaster for them. The case was settled out of court for a massive sum, but the message was sent. This was a lawyer who understood that the battle is fought not just in the courtroom, but in the court of public opinion. He protected his client's financial interests and her reputation simultaneously. These wars are wars of attrition. A major studio can afford to spend millions of dollars on a single case without blinking. For an individual artist, it can mean financial ruin. The legal fees are staggering. This is the corporation's ultimate weapon. They can simply outspend you. A brilliant lawyer knows this and has to plan for it. They might work on contingency, taking a percentage of the final settlement instead of an hourly fee. Or they might seek out litigation financing, where a third-party company pays the legal bills in exchange for a share of the winnings. They have to be as creative with the business of law as they are with the practice of it. The fight isn't just about being right. It's about having the resources to prove you're right. It's a brutal, exhausting, and often lonely fight. Your lawyer is your general, your shield, and your strategist, leading the charge against an empire. But even if you win the legal battle, have you lost the war for your career? The industry has a long memory, and taking on a titan can get you labeled as difficult. So how does a lawyer navigate the treacherous waters of Hollywood politics after the verdict is read? It's a brutal, unspoken truth of the entertainment world. You can win the battle and lose the war. The verdict might be in your favor, the settlement check might be cashed, but the whispers in the executive suites and the polo lounge have already started. Difficult. Litigious. A problem. That single word, that label, can be a career death sentence. So the lawyer's job isn't over when the gavel falls. In many ways, it's just beginning. Their role shifts from courtroom gladiator to something far more nuanced. A reputation strategist, a political operator, and a career resurrection artist. Navigating Hollywood politics post-lawsuit is like playing chess on a minefield. The first and most critical strategy often involves avoiding the public verdict altogether. This is the hidden genius behind the out-of-court settlement. To the public, a settlement can look like a cop-out, a sign that one side didn't have the stomach for a fight. But inside the industry, it's understood as a strategic masterstroke. A savvy lawyer isn't just negotiating a dollar amount. They're negotiating the narrative. They're fighting for every word in the joint press release. Phrases like amicable resolution, mutual respect, and wishing each other the best in future endeavors aren't just corporate fluff. They are carefully constructed peace treaties designed to signal to the rest of the industry that the war is over, and it's safe to work with their client again. The most powerful tool in this negotiation is the non-disclosure agreement, the NDA. It's not just about keeping the settlement amount secret. It's about total narrative control. A well-drafted NDA can legally bar both sides from ever speaking ill of each other again. It effectively muzzles the opposition. So when a journalist asks the studio executive about your client, they are legally bound to give a neutral, or even positive, response. The lawyer has used the law to rewrite the ending of the story, transforming a bitter conflict into a footnote that everyone has agreed to forget. This allows the client to walk back into the industry not as a victor who gloats, but as a professional who handled a business dispute discreetly and moved on. In Hollywood, discretion is currency. But what happens when the fight is too public, too messy to be swept under the rug with a press release? What about the cases that dominate the headlines for months? This is where the lawyer must become a public relations crisis manager. The goal is to pivot, to change the conversation. If the lawsuit painted their client as a greedy artist fighting for more money, the lawyer, working with a PR team, will orchestrate a new narrative. Suddenly, the client is doing a high-profile charity tour. They're giving interviews not about the lawsuit, but about their passion for the craft, their love for their fans, their next creative project. The lawyer's legal advice now extends to which talk shows to appear on, which journalists are friendly, and how to answer the gotcha questions. They are meticulously washing away the stain of the lawsuit and repainting their client's public image. It's a calculated campaign to make the industry and the public remember why they fell in love with the artist in the first place, and forget the messy business of the court case. Think of it this way. A musician wins a landmark case against their record label for unpaid royalties. They're vindicated, but now every other label sees them as a potential lawsuit waiting to happen. Their lawyer's next move isn't to file another suit. It's to get their client back in the studio. But not just any studio. They might arrange a collaboration with a universally respected, legendary producer. They might advise the client to self-fund an EP and release it for free. a gesture of goodwill to the fans, recasting the artist as a champion of the people, not a money grabber. The legal win gave them the financial freedom to make these moves. The lawyer's strategic advice gives them the roadmap to turn that financial win into a career renaissance. Then there's the art of leveraging the outcome itself, turning a potential negative into a powerful positive. A great lawyer helps their client own the story. Let's say an actress sues a producer for discrimination and wins. The risk is that she'll be labeled a troublemaker. The lawyer's job is to reframe her as a trailblazer. They don't let her just fade away after the verdict. They help her channel that victory into a cause. They might help her set up a foundation to support other women in film. They might secure her a book deal to tell her story, inspiring others. They help her get speaking engagements at industry events. She is no longer the actress who sued a producer. She is now a powerful advocate for change, a leader in the industry. The lawsuit, which could have ended her career, has now become the foundation for a new, more powerful one. The lawyer didn't just win a case. They architected a legacy. This applies even in a loss. Sometimes the court of public opinion is more important than the court of law. If an artist loses a case but, in the process, exposes deeply unethical industry practices, their lawyer can help them frame that loss as a moral victory. They become the brave whistleblower who knew they couldn't win against a billion-dollar corporation, but fought the good fight anyway. This can generate immense public support and goodwill, which can be translated into new opportunities: a documentary, a crowd-funded project, a record deal with an independent label that values their integrity. Consider a hypothetical screenwriter who proves a studio stole his blockbuster idea. He wins millions, but the phone goes silent. He's radioactive. His lawyer, understanding the real fight has just begun, takes a portion of the settlement and advises the writer to option a famous, beloved novel. It's a power move. They are no longer a writer begging for a job. They are now a producer with a hot property. The lawyer then brokers a meeting with a rising, ambitious director, and together they package the project. They take it not to the major studios, but to a streaming giant hungry for prestige content. The lawyer used the fruits of the old war to finance a new campaign, bypassing the old guard and establishing their client as an independent power player. They didn't just get him a paycheck, they bought him a seat at the table. This high-stakes game of three-dimensional chess, part law, part PR, part career coaching, is the hidden value of a top entertainment lawyer. They don't just clean up the mess. They rebuild the house, stronger than before, and with better security systems. But what if you could avoid the fire altogether? What if the most important, most valuable work a lawyer does happens years before a single courtroom is ever mentioned, in the silent, ink-filled pages of a contract designed to be a fortress? That fortress is a contract. And it's not built with stone and mortar, but with clauses and subclauses, with definitions and declarations, with ink on a page that carries the weight of a career. Most people think of a contract as a formality, a necessary evil, a dense, unreadable document you sign to get to the good stuff. But in the world of entertainment, the contract is the good stuff. It is the beginning, the middle, and the end of the story. It is the DNA of the deal, the architectural blueprint for everything that will ever happen between an artist and a studio, a songwriter and a publisher, a director and a production company. An ounce of prevention, they say, is worth a pound of cure. In Hollywood and Nashville, an ounce of contractual foresight is worth a metric ton of litigation gold. Let's build this fortress together, clause by clause, and see how a single sentence can be the difference between a legend and a cautionary tale. The foundation is the deal itself, the money, the term, the territory. How much are you getting paid? For how long? And where in the world does this agreement apply? Simple questions with catastrophically complex answers. But this is just the ground floor. The real protection comes from the walls, the moat, and the watchtowers. The walls are what lawyers call representations and warranties. This is the section where each party swears certain things are true. It sounds simple, almost polite. I, the songwriter, represent and warrant that I wrote this song, that it is wholly original, and that it doesn't infringe on any other copyrighted work. That one sentence is a load-bearing wall for the entire structure. Imagine a young, hungry producer crafting a beat in their bedroom. They find an obscure, haunting vocal snippet from a 1950s blues record on YouTube. It's perfect. They chop it, pitch it, build an entire track around it. The track gets to a major artist, it becomes the backbone of a global #1 hit. The song is everywhere. The producer is a star. And then the phone rings. It's the estate of that 1950s blues singer. They never gave permission. The sample was never cleared. Now, look back at that contract the producer signed with the record label. If their lawyer was asleep at the wheel, the contract might be vague. But if their lawyer was a fortress builder, that reps and warranties clause is ironclad. It says the producer guarantees everything is original or cleared. And right next to that wall there's a moat. It's called an indemnification clause. This clause says, if I breach my warranties and you, the label, get sued because of it, I am responsible for all of your legal fees, settlements, and judgments. The hit song that was meant to build a career now becomes a multi-million-dollar debt that will follow that producer for the rest of their life. The label is protected. The producer is ruined. A lawyer's job is to not only make sure their client understands that clause, but to do the due diligence to make sure they're not signing their own death warrant. They are the ones asking the tough questions. Are you sure every single sound in this track is yours? Let's talk about that vocal snippet. Now for the watchtowers. These are the audit and accounting clauses. They are the lookouts, constantly scanning the horizon for incoming financial threats. And nowhere is this more critical than in the film industry, a place famous for an accounting system so creative it can make a billion-dollar movie look like it lost money. You've probably heard of net profits. Sounds fair. The studio pays all the costs, and once they've made their money back, you split the profits. It's the deal that countless actors, writers, and directors have taken, dreaming of a massive payday on a blockbuster hit. The problem is the definition of net. The studio writes the definition, and their definition includes things you can't even imagine. Distribution fees they pay to a sister company they also own. Marketing costs with massive overhead charges. Interest calculated at rates that would make a loan shark blush. The result? The movie Forrest Gump grossed over $670 million. The author of the book it was based on, Winston Groom, was famously told that thanks to Hollywood accounting, the film was still not in net profit. David Prowse, the actor inside the Darth Vader suit for the original Star Wars trilogy, was entitled to a share of the net profits of Return of the Jedi. To this day, despite the film being one of the highest grossing of all time, he has never received a check, because Lucasfilm maintains it has never made a net profit. A sharp entertainment lawyer sees the words net profits, and the alarm bells don't just ring, they shatter the windows. They fight it. They argue for points on the gross, a percentage of the money that comes in before the studio's magical accounting starts subtracting costs. If they can't get gross, they fight to redefine net. They cap marketing expenses. They eliminate overhead fees. They demand the right to audit the studio's books. They build a watchtower with a powerful telescope and an army of accountants ready to storm the castle if the numbers look funny. Without that lawyer, the artist is just standing on the ground hoping the king will be generous. Finally, every fortress needs an escape hatch. What happens when the deal goes sour? When the creative partnership falls apart? When the record label shelves your album and refuses to release it? This is the world of termination clauses and cure periods. Consider the classic music industry trap, the 7-album deal. It sounds like a dream to a young band. Security, a long-term commitment. But what if the first album is a flop? The label can drop them. What if the first album is a colossal success? The band is now locked in for 6 more albums at the same low introductory royalty rate they agreed to when they had no leverage. They are trapped in golden handcuffs, generating millions for the label while they barely see a dime. A good lawyer anticipates both success and failure. They build in escape hatches. They'll negotiate for a shorter term, maybe a 2-album deal with options for more. They will demand that if an option is exercised, the royalties and advances have to increase. They will insert a release commitment, a clause that says if the label doesn't release an album within a certain time frame, the rights revert back to the artist and they can walk away. They are planning for the divorce before the marriage has even begun. Because in entertainment, passion fades, relationships break, and empires fall. When that happens, the only thing you have left is what's written on the page. So this document, this contract, is not just paper. It is a time machine. It is a crystal ball. It is the lawyer looking into every possible future. The good, the bad, the ugly, the wildly successful, and building a structure that can withstand all of it. They are not just protecting their client from what might go wrong. They are creating the very foundation upon which a long and prosperous career can be built. They are turning a dream into a business, and a handshake into a legacy. The contract is the fortress, and the lawyer is its architect. But what happens when the architect becomes the strategist? The general? The one person in the room who sees the entire map, not just the battlefield in front of them? That's when a lawyer transcends their title and becomes something more. That's when they become a true power broker. And what does that power broker do? They don't just play the game. They change the board itself. They look at a career not as a series of contracts, but as an empire to be built. They see a legacy not as something to be protected, but as an asset to be leveraged, grown, and immortalized. There is no greater example of this in modern history than the story of what happened after the world lost the king of pop. When Michael Jackson died in 2009, the narrative was one of tragedy and chaos. He was, by most public reports, nearly $500 million in debt. His personal brand, once the most powerful in entertainment, was fractured. The future of his vast, but complicated musical legacy hung precariously in the balance. Most people saw an ending, a tragic finale to a legendary life. But his longtime lawyer, John Branca, saw something else entirely. He saw a beginning. Appointed as a co-executor of Jackson's will, Branca's role instantly transformed from legal counsel to that of an architect of a resurrection. This was no longer about negotiating tour riders or album advances. This was about rebuilding a global enterprise from the ground up, with its CEO gone. The first move was pure genius, turning the greatest potential liability into the first foundational block of the new empire. Jackson had been preparing for a massive comeback tour called This Is It. Hundreds of hours of pristine, high-definition rehearsal footage existed. To the concert promoters, this was a disaster. To Branca, it was gold. He and the estate didn't just shelve the footage. They orchestrated a deal to turn it into a feature film. Think about the legal complexity of that pivot. They had to negotiate with the concert promoters, AG Live, to release their claim on the footage. They had to strike a massive distribution deal with Sony Pictures. They had to do it all under the intense pressure of a global media spotlight and a grieving fan base. The resulting film, This Is It, became the highest-grossing concert film of all time. It didn't just generate a colossal amount of money to start paying down the debt. It fundamentally shifted the public narrative. It reminded the world not of the controversy, but of the genius. The lawyer hadn't just made a deal. He had conducted a masterstroke of public relations, turning mourning into celebration. But that was just the opening act. Branca and the estate then began to look at Jackson's music catalog, not just as a collection of songs, but as the source code for new experiences. They brokered two monumental deals with Cirque du Soleil, creating Michael Jackson, the Immortal World Tour, and the Las Vegas residency Michael Jackson won. These weren't tribute shows. They were immersive, multi-million-dollar theatrical productions that introduced his music to an entirely new generation, generating hundreds of millions in revenue and keeping the brand alive and vibrant. Each deal was a universe of intellectual property law, licensing agreements, and international business negotiations. And then came the master move, the Grand Slam. For years, Michael Jackson had owned a stake in the Sony/ATV music publishing catalog, a treasure trove that included the rights to songs by the Beatles, Bob Dylan, and Taylor Swift. It was arguably the most valuable music publishing catalog on the planet. Branca, who had helped Jackson acquire it in the first place decades earlier, now saw the moment to capitalize. In 2016, he orchestrated the sale of the estate's half of the catalog to Sony for $750 million. In a single transaction, a lawyer's long-term vision wiped out the entirety of the debt that had plagued Jackson for years and turned the estate into a financial juggernaut. From $500 million in the red to a multi-billion-dollar enterprise, it is, without question, one of the greatest posthumous business turnarounds in history, and it was engineered not by a record executive or a Wall Street banker, but by a lawyer who understood that his client's true value wasn't just in what he created, but in the legacy he left behind. This is the ultimate evolution of the entertainment lawyer. They are the guardians of the past, the architects of the present, and the visionaries for the future. And that future is more complex and treacherous than ever before. The legal battles of tomorrow won't be fought over sample clearances or film distribution rights. They'll be fought on the digital frontier. Think about artificial intelligence. What happens when an AI can perfectly replicate the voice of a deceased singer? Who owns that performance? The estate? The tech company that created the algorithm? Can an AI-generated script using the style of a famous screenwriter be considered a derivative work? Lawyers are now drafting contracts for scenarios that sound like science fiction, creating clauses to protect an artist's digital likeness from being used in deepfakes or unauthorized virtual performances. They are defining the very essence of identity in an age where identity can be coded. Consider the world of Web3 NFTs and the metaverse. For a century, ownership in entertainment was tangible. You owned the film negative, the master recording, the copyright registration. Now, lawyers are structuring deals for digital assets that exist only on a blockchain. They are figuring out how to apply century-old copyright law to decentralized virtual worlds. How do you sue for copyright infringement in a metaverse that has no physical jurisdiction? These are the questions that keep entertainment lawyers up at night, because they are not just interpreting the law, they are building the legal framework for a new reality. And all of this is happening on a global stage. The content wars between Netflix, Disney, Amazon, and Apple are not just about creating shows. They are about global acquisition and distribution. A lawyer structuring a deal for a new series has to navigate the tax laws of Ireland, the censorship regulations of multiple Asian countries, the intellectual property treaties of the European Union, and the labor guild requirements of Hollywood, all in a single contract. They need to be a diplomat, a global economist, and a legal scholar all at once. So when you watch the next blockbuster or stream the next chart-topping album, or see a legendary artist's name on a new product years after they're gone, remember what's behind it. It's not just talent and creativity. It's not just marketing and money. It is a complex, invisible architecture of legal strategy. It's the product of a lawyer who fought for the right percentage point, who protected the crucial copyright, who saw a crisis and framed it as an opportunity, who looked at a contract and saw not a document but a destiny. They are the ghost in the machine, the author of the fine print, and in many ways the uncredited producers of the culture we all consume. They don't just practice the law. They write the rules of the game,